This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Now, without further ado, I pass it on to you, Judge Rosenblatt, who will be kicking off our program today titled Employment Mediations and Arbitrations in 2021 and Beyond.
Thank you, everyone, for attending our employment webinar. Following the seminar, you will receive a PDF of the slides and 3 articles. A word about accessibility. Other than the photos of the speakers, the ADR Services logo, and an Art Deco design, there are no graphics or photos in this presentation. I'm Michelle Rosenblatt, Judge Rosenblatt, and it is my pleasure to introduce you to our speakers today. Incredible speakers, actually. Phyllis Cheng is a neutral at ADR Services where she mediates labor and employment, civil rights, and other matters. She also serves on the mediation panels of the California Court of Appeals, Second Appellate District, the U.S. District Court, Central District of California, where she leads its mediation practice group. Phyllis has served in the administrations of Governors George Majian, Pete Wilson, Arnold Schwarzenegger, Jerry Brown. She was director of the DFEH, vice chair of the Fair Employment and Housing Commission, and member of the Commission on the Status of Women and Comparable Worth Task Force. She was a partner at D.L. Piper's employment group of counsel at Littler Mendelson, an associate at Hadsel and Stormer. She was also a research attorney at the Second District Court of Appeal, Division 7, and was Deputy Attorney General at the California Department of Justice's Civil Rights Enforcement Section. Phyllis is the managing editor of the California Labor and Employment Review, where she has written a column on cases pending before the California Supreme Court for 18 years, the latest edition of which will be in your materials. In addition, she is co-editor of the California Fair Housing and Public Accommodations Rudder Group, writer of California Labor and Employment Case Law Alert, and contributor to Rudder Group's California Employment Litigation. The state bar named Phyllis Cheng the 2014 Ronald M. George Public Lawyer of the Year. Our next speaker is Mark LeHocky. Mark is a mediator with ADR Services who previously served as general counsel for Nestle, Dreyer's Grand Ice Cream Incorporated, and Ross Stores Incorporated. Prior to his general counsel days, Mark spent 20 years litigating commercial, IP, antitrust, class action, and other disputes for clients ranging from small businesses to Fortune 100 companies. As general counsel, Mark crafted and tested company-wide dispute resolution programs. After helping to design Dreyer's multi-stage merger transaction with Nestle, Mark also developed ADR and litigation management training for Nestle attorneys worldwide. Mark began mediating 2 decades ago when appointed by the federal court to resolve complex cases. He has since been repeatedly voted a best lawyer in America for mediation by U.S. News Best Lawyers. Mark has also taught mediation advocacy at UC Davis School of Law and today teaches at UC Berkeley's Law School and Haas Graduate School of Business on the intersection of law, risk management, and effective decision-making. 2 of Mark's articles will be in your materials. I am a mediator and arbitrator with ADR Services. I was on the bench for 23 years. I was appointed to the now outdated Los Angeles Municipal Court in January of 1993, and the Los Angeles Superior Court 4 years later in 1996. While in the Burbank Courthouse and the Mosque Courthouse, I presided over, settled, and heard trials on a wide range of civil cases, a majority of which were employment. Since 2016, I have been a neutral with ADR services. I mediate a range of civil disputes, the majority of which are FIHA, wrongful termination, and wage and hour cases. While on the court, I co-chaired the LA Superior Court monthly civil education program and participated in civil education statewide. I was a vice president of the California Judges Association, president of the California Judges Foundation, and editor of the California Judges Association magazine. In 2007, I was named Judge of the Year for the San Fernando Valley Bar Association. A word about accessibility I've already given to you. And so at this time, I'm going to ask for the next slide. The goals of this course: to spot pandemic employment issues, to discuss how this impact will the pandemic will impact the mediation and arbitration of employment cases in 2021 and beyond. Next slide, please. In 1966, while speaking in Cape Town, Robert Kennedy quoted the following curse: "May you live in interesting times." He went on to say, like it or not, we live in interesting times. They are times of danger and uncertainty, but they are also the most creative of any time in the history of mankind. Isn't that where we are? And that's why we've been experiencing court delays, financial uncertainty, new workplace structure, culture, and rules ever changing, remote hearings, mediations, and arbitrations. Let's go back to our, no, I'm sorry, please go back, Phyllis. Back to our speakers, please. To our speakers, please. Sorry. We're still on pandemic's impact. Beautiful. Thank you so much. So here's my question for our panelists, and why don't we start with Mark. How have these realities impacted mediation up until now?
Well, we're all dealing, as you said, we're living in a world of flux right now. The laws and regulations relating to the pandemic are still playing out in front of our eyes. For those of us who had to shift immediately into the world of mediation and arbitration and teaching, in a Zoom world, we had to make a lot of quick adjustments. And the balls are still very much up in the air. We'll talk about some more specific things in a few minutes, but we're in a state of flux. How it plays out in terms of mediations, I know we'll talk about as we go through the time period. But we've had a lot of people, I'm sure both of you have encountered a lot of people in mediation where they're trying to address a dispute and the world's uncertain. In employment in particular, we've all encountered many situations where you don't know what's going to happen next. And we've all encountered those situations where how do we settle this case where that next job may not be there, or may not be there for a long time. And that has made the last 15, 18 months kind of a challenging period in terms of figuring out value. Even talking about issues like mitigation, what's reasonable when the world's topsy-turvy. Now it'll stabilize, it's starting to stabilize with a little more predictability going forward. But definitely we have to factor in what the last 15, 18 months has done and the residue that we're still going to be dealing with, I think, for the years to come.
And thank you. And Phyllis.
Well, I think that in the beginning, it was very difficult for everybody to adjust to this new paradigm of everything going virtual. The courts were not prepared, the parties, counsel were not prepared. But I think that after all these months, we have kind of gone into a new era of everyone being accustomed to dealing and resolving issues online, virtually. And I have to say that I believe the settlement rates, the effectiveness of virtual mediation and maybe virtual arbitrations as well are going very well. And in fact, I always ask counsel when I do a mediation whether they plan to continue using virtual platform. And the vast majority of people like it, are accustomed to it.
So I agree with what both of you said, so I won't add my 2 cents now, but let me go to the next question. Are remote mediations here to stay? And Phyllis, you had really addressed that. So let me ask Mark your position on that.
Yeah, they are definitely here to stay. That I think we will go back to in-person sessions. I will confess, having been doing remote mediations for a dozen years plus, back in the old days where there were pretty antiquated products like Skype, it was not pretty at all times. So I tried to avoid it. I tried to always work in person, but there's some significant silver linings here. The most significant from my perspective is the ability for people to participate more easily. And in a lot of my cases, I might otherwise have people who would not show up themselves. They'll delegate somebody else to show up, whether it's a general counsel, a senior person in an insurance company, somebody in a corporation. And that sometimes works fine. But the real positive news from my perspective, the last year and a half, has been the number of times people participate who are more senior, more significant decision makers. Now, I want to be really careful not to say anything bad about younger people participating. They have to learn, they have to participate. Oftentimes they've done the real work, so they have to be there too. But when you have the combination of people that wouldn't otherwise make the trip, spend a day flying from Taipei or Munich or New York or wherever, and then shuttle back and forth, good things happen. Things get done faster. And as we all know, is part of the mediation process, there's twists and turns, and there's a need to react to those twists and turns. So that's been a great positive thing from my perspective. And so my view of the world, it will have a hybrid of continuing Zoom sessions, especially early on, but hopefully a nice mixture of some in-person sessions and some Zoom sessions to take advantage of this technology.
Sorry, Phyllis, please go ahead.
I also think it's an economic equalizer for people who ordinarily wouldn't be able to travel or drive or pay high fees of parking to participate. And as Mark said, that geographically, I had parties who were able to Zoom in from Mexico who ordinarily would not be able to afford the trip. So I do think in so many ways, it's an equalizer, and it makes everybody be able to participate.
That's right. People from all over the country, all over the world, potentially, and we can talk more about that, but people who are unable to travel, where they don't drive, because of disabilities or other reasons, who can now attend. There's also a factor that is really interesting. In some cases, it is more comfortable for a party to be in their own surroundings, or alternatively with their own lawyer or in their lawyer's offices, even if it's in a different room, because when they come into the offices to mediate, just like going to court, it's a whole new atmosphere, and it may raise their anxiousness a bit, but when they are in their own environments or an environment with they're with their own counsel, it may be easier for them to concentrate on what they need to in order to help us help them resolve their cases. So what about remote arbitrations? Do you think they're a short-term workaround, or do you think they're hard to stay? I'll ask Mark this question.
Well, again, I think it's our future is probably a hybrid future. Even before COVID hit, when I would do arbitrations, I would do most of my preliminary hearings, case management conferences, those sorts of things in this kind of format, because it is more efficient and saving people a lot of travel time and expense. So I think so. Now you do, Judge Rosenblatt, more arbitrations. And I'd love to hear your thoughts about what the change has been like.
Well, the arbitrations have worked beautifully remotely. I've also done hybrid, and which is really important to talk about. I think that that for attorneys who like to present and perform, they like being with us. You know, they like being in a room with us and being able to do that and have us see all of their client, not the client's face. I understand that. But I think in terms of being able to assess credibility, being able to focus on the attorney's arguments, all of that this forum has been fantastic. Now, hybrid arbitrations, if not remote arbitrations, at least hybrid arbitrations, I believe, are here to stay. I also would hear a case in person and then an occasional witness remotely before the pandemic, or right at the start of the pandemic before I realized I needed to go home, right? But actually, it works very, very well. So what I've done and what I foresee is being in a room with attorneys and parties, and then having some or all of the witnesses testifying remotely. So you can have someone, again, from out of state, from out of the country, and so forth. I just real quickly, must have been at least 10 years ago, I had a case had to do with foreign judgment. Doesn't really matter what it was about, on LA Superior Court. Okay, it was a bench trial. And in that particular case, there was a solicitor and a lay witness in the UK. And the attorneys talked to me about having those witnesses appear remotely. We set that up. So it was by written stipulation. That's the only way in the world we could have done this. But we set it up with the court's technical folk. It certainly was not of the quality that we have today. It wasn't like this Zoom feature, but we were able to hear the testimony of those witnesses beautifully. We got whatever exhibits they needed to them. We didn't have screen share, but we got whatever exhibits they needed to them in advance, and it worked. It worked fabulously well. At that time, there's no way I would have been able to convince more than a handful of lawyers to do it that way. I think the situation has changed today. I really do. Anything to add, Phyllis?
I do have one thing to add, and this would be true for arbitrations and for mediations, and that is in terms of going back to a physical mediation. I did do one while we opened up momentarily in the spring. It's very difficult if some of the people are vaccinated and other people are not. So I had certain people, and well, at that time, most people were not vaccinated. So everybody had assigned seats, they had to wear masks, and to wear a mask for 8 hours It's very uncomfortable. It's also difficult to see people's expressions, so it's difficult for you to gauge credibility, to see how people are emoting with you. So I do think that unless everybody is vaccinated, if somebody's masked and other people are not, that's the only drawback, I think, of a physical participation.
It is a drawback. I did an arbitration not that long ago, but when masks were still required for all and so forth, and wearing the mask all day was the most difficult part of the day, or the week actually. But I thought it would be more difficult to assess credibility than it really was. You know, it was okay. It was fine. You know, I prefer being able to see everyone's faces. So, why don't we go to the next slide? And this is the state of the courts under the pandemic.
I do like this background, though.
It's beautiful, yeah. Okay, wonderful, thank you. So judges' civil caseloads have at least doubled due to the shutdown and the inability to bring jurors into court. Cases that are preference trials and bench trials are being heard, but sort of, but the need to hear criminal cases and certain other cases are bumping back the civil cases, and some of them, of course, that means are butting up against the 5-year rule. You know, there are emergency rules on that. But you know, it's unlikely that you're going to see civil trials. There will always be a few. There have been some around the state, but very unlikely that many of them will go before 2022. Courthouse logistics are inhospitable. It's true. Next slide, please. So, ripped from the headlines, couple examples in the news. I've seen, I'm sure there's more, 2 different out-of-state actions brought by hospital workers, I think one by ER docs, that one surprised me, where, and by the way, they were dismissed by the trial court, but they were objecting to a vaccine mandate in order to be able to come into the hospital. So who knows what will happen with that, if those rulings will be taken up. Just today, I saw in the LA Times that, one of those was a Texas case. Today in the LA Times, there was an article that 153 Houston hospital workers lost their jobs after refusing to get vaccinations. There was a case in the news just the other day about an LA County school district where there was an anticipated vaccine requirement for teachers, and it's being challenged already in the courts. These sites are great. As of April 2021, there were 2,379 lawsuits filed against employers. Take a look at this website because it is up to the minute every day on the number of lawsuits with a breakdown. Each of the articles that are attached here will give you further information about what's going on in the courts. I would really like to hear if we could go back to speakers, please. what types of COVID-related employment mediations you've seen so far. I have seen cases involving PPE, no barrier in a retail store situation. Employer argues it's not needed because the employee is mainly not behind the counter and everybody wears masks. And employee says, well, people come up to the counter and spend time with me when I'm behind the counter. I need my barrier. And of course, that results in wrongful termination. So that's the type of cases. In the early cases I was hearing, that's obviously changing and going to change. Mark, what about you?
Well, I think probably like all of you, I run into a lot of cases. I call them kind of COVID triggered or COVID enhanced, exacerbated reductions in force. A lot of companies that made some significant decisions early on in the pandemic to cut their workforce, furlough people, if not terminate them outright. And I'm dealing now with multiple cases where there are challenges about whether that was the right decision, with the benefit of hindsight. And of course, the response is, what were we to do in an uncertain time period? I think those cases will play out for a while. And I think with most of the things we're talking about, at least my focus is often what was reasonable under the circumstances. How will that be perceived if we're not able to settle? I'm talking mediation right now, not the arbitrator role, but did you act reasonably under the circumstance? I mean, if I could channel my old general counsel days, we encountered lots of crisis events, data breaches, unfortunately shootings, hurricanes. And I remember being in too many meetings with people that would say, turn to me as the lawyer and say, well, what do we do? What do we legally do? And my response is, we do the best we can, thinking about our shareholders, our employees, our customers. And yes, we may get challenged, but if you're always looking through things like do the best you can, yes, you may be legally in violation of a rule, but that'll impact the settlement prospects. It'll impact how you think about damages. It'll impact how a court might think about penalties. So I think that's the world we're in. And those uncertainty factors, in my view, during the mediation work, are positives to talk about to get people to compromise and reach a deal.
Yeah, because they're the risks of the day, the uncertainties of the day. Phyllis, how about you?
Well, I've been seeing quite a lot of mixed disability and COVID-related cases. In the past, if somebody had a disability and they asked for an accommodation or a leave, they got to work at home or they got to stay home. And now that most people are working from home, they already kind of have that accommodation. There are also some workers' comp and disability crossover issues. For example, I had a case in which a person who did telework went to change a light bulb in her home office and fell from a ladder and was injured. So, there was a triggered a workers' comp claim and disability claim at the same time. But it's very difficult to reasonably accommodate somebody who's already working from home. So that's one of the things I see. I also have mediated a perceived COVID disability case in which the employer felt kind of paternalistic about the employee because she had an underlying medical condition of diabetes. Even though she never contracted COVID, they were concerned that if she were to get COVID, because it was a store, then that would trigger, issues, and they were afraid that they'd have to change the air conditioning system. So they placed this employee on kind of permanent unpaid leave, which of course is a violation of the FIHA. So I see that kind of crossover case, maybe as people become more familiar with and know more about COVID, we will see less of that. But my sense is that we're going to be seeing a lot of COVID cases in the next few years.
Yes, and in as much as we see cases involving inability to get breaks or a full, lunch hour and so forth. When somebody's at the work site, we're seeing them when they're working from home as well, with the worker saying they have too much work and therefore no time. So it's really very interesting in that respect. Could we have the next slide is for you, Phyllis.
So recently you've seen in the news a lot of information about Governor Newsom lifting the pandemic executive orders, and there were many of them. That was they lifted them on June 11th. So the economy is now going beyond the blueprint for dealing with COVID and started reopening June 15th very recently. So the governor terminated the stay-at-home order. He eliminated physical distancing, capacity restriction, and county tier system. There were, three color-coded systems, as well as the requirement for masks for vaccinated Californians. And there is also a gradual wind down of the 58 COVID-related executive orders between June and hopefully everything will be lifted by September of this year. So Michelle, do you want to take the hypo?
No, it's you.
Okay, all right. Okay, so we have a hypothetical that we want you to consider, and we are going to go over the law, and we want you to think about some of the issues related to this, and we will further discuss questions related to this hypo, but just for you to think about in advance. So ABC Hotel recalls workers laid off during the pandemic, and then required all returning employees to show proof of having been inoculated with a CDC-approved COVID-19 vaccine. And as you know, there's several of them. So Chef, a laid-off cook, refused to be vaccinated on account of that person's phobia about needles and religious belief against using vaccines. So Chef asked to telework or to be placed on an extended leave. And as you know, it's difficult to cook on an extended leave or teleworking. Anyway, ABC immediately terminated Chef and hired a brand new employee who had not been laid off before to replace Chef. Then Chef filed complaints with the DFEH and DLSE, the Department of Fair Employment and Housing and the Labor Commissioner. The case is then mediated. So given these facts, think about it. And we're going to be telling you about changes in the law so that you can think about some of the remedies to this hypo. So in terms of recall, many jurisdictions, municipalities, especially large ones like LA, Long Beach, San Francisco, Pasadena, San Diego, and Oakland, all have recall ordinances, different ones that apply to certain sectors. So basically that means the employers who have laid off employees because of COVID during this period of time must recall these employees back in a certain way. There, of course, collective bargaining agreements can also have recall rights. So if you're going to be giving advice to your client, it would be really important to look into these municipal restrictions or recall ordinances and take a look at whether there are any collective bargaining agreements that have a certain order of recall. The legislature passed an emergency legislation, SB 93, that became effective April 16th and will sunset December 31st of 2024. So this statute is going to be around and effective for 3.5 years or so. It requires certain employers. The employers are hotels, private clubs, event centers, airport hospitality operations, janitorial, maintenance, or security services, retail, and other commercial buildings. It also includes temporary service, staffing agencies, or successor employees. So if any of those employers had laid off staff during COVID, they would be impacted as covered employers. Who are the covered employees? Well, if an employee is an employer by any of these covered employers for 6 months or more in the 12 months preceding January 1st, 2020. So that means from January 1st of 2019 up to present, then the most recent separation due to a reason related to COVID-19, or perhaps, public health directive or government shutdown order or no business, reduction in force, or any other economic reasons, those employees would be so-called covered employees protected under SB 93. Only valid collective bargaining agreements can be a waiver to the application of SB 93. Now, clearly, the California legislature is very serious about the rehire provisions because it has allocated $6 million appropriated to the Division of Labor Standards Enforcement, or the Labor Commissioner, to enforce the law. And the penalties are $100 in civil penalties per employee and $500 liquidated damages for every day of the violation per employee. So if you work in wage and hour, this is potentially, even temporarily, a huge statutory remedy that would be available on the rehire of anybody laid off in these industries for COVID reasons. So watch out for SB 93. Okay, so there have been a lot of confusion because of the lifting of the executive orders on the very extensive Cal-OSHA emergencies temporary standards regarding COVID. So these, what we have listed here in bullet point, these are the ones that are going to be staying in place. So this part is not going to change. You have to have a COVID prevention policy in writing. The employer has to provide training and instructions on the employer's prevention plan and employees' rights under the emergency temporary standards. The employer still has to notify public health departments of any kind of COVID outbreaks. The employer has to notify employees of any exposure or close contact in the event of a COVID issue. The employer has to continue to offer testing for potential exposure. So if any employee came down with COVID, then the employer has to offer testing. Responding to COVID-19 cases and outbreaks, quarantine and exclusion requirements in case of an outbreak, and finally, prevention for employer-provided housing and transportation in terms of COVID. So these are continuing requirements. What are some of the changes that are going to take place under Cal-OSHA? Well, an important one is fully vaccinated employees without any symptoms do not need to be tested or quarantined after having close contact with COVID-19 cases, unless they have symptoms. So basically, if an employee has been vaccinated with COVID, they don't have to wear masks. And they don't have to be quarantined. And so the next one is no face covering. We already covered that. No face covering regardless of vaccination status. So that is kind of a tricky area for employers because, well, some places required, continue to require face coverings, other ones do not. And it's very difficult. Some people may choose to wear face covering. So, but nonetheless, a face covering requirement outdoors is no longer required regardless of vaccination status. An employer can also allow fully vaccinated employees to not wear face coverings indoors, but they have to document their vaccination status. There are some exceptions to that as well, which you can read on this website, which is has a link on it. The employers must also provide unvaccinated employees with approved respirators for voluntary use when working indoors in a vehicle with others upon request. I don't know why anyone would need to have respirators, but these are regarding unvaccinated employees, and that you could have employees who might have allergies, or they might have a religious reason to not be vaccinated. So if they require or ask for a ventilator, respirators, employers may still be required to do that. As I said, the Cal OSHA rules are changing all the time. This might change later on, but for now, this is a new requirement. Employers may not retaliate against employees from wearing face covering. So if somebody says, I know I don't have to wear a face covering, I've been vaccinated, but I don't feel comfortable unless I wear a face covering, the employer cannot retaliate against them from because they want to wear it. Another continuing some of the changes, the Cal OSHA does not require physical distancing or barrier requirements regardless of the employee's vaccination status. You will see that in supermarkets and stores, we no longer see those 6 feet, painted barriers of how far away you have to stay from the next person. However, there are some exceptions. The employers must evaluate whether it's necessary to implement physical distances during an outbreak. So an outbreak is defined as 3 or more cases in an exposed group of employees. So documentation and being aware would be very important for an employer upon reopening. Another exception is employers must implement physical distances and barriers during a major outbreak. That would mean 20 or more cases in an exposed group of employees. Again, documentation would be very critical. There's no physical distancing requirement in the employer provided housing and transportation regulations. When all employees are vaccinated, then employees are exempt from these regulations in housing and transportation. And finally, employers must evaluate their ventilation system to maximize outdoor air and increase filtrations and efficiency, and evaluate the use of additional air cleaning systems. So there's a lot of work for employers to do under the new Cal OSHA temporary standards. In addition, even though we have COVID-19, we still have to comply with all the civil rights laws, and both the DFEH and the EEOC have provided extensive guidance, and I encourage you to click on these links to go through them. Basically, unlike other types of disabilities, under COVID-19, employers can require returning employees to be inoculated with vaccines approved by the FDA. Employers who administer a COVID-19 vaccination program, some employers have their own vaccination programs. They may ask employees questions related to COVID-19 intended to elicit information about their disability if they have a disability. If in fact the questions are job related and consistent with business necessity. An employer can also ask for proof of vaccinations if the employees are directed to a third party. So they can ask for proof of vaccination, which you normally cannot do for other types of medical conditions or disabilities. Records of vaccinations are confidential medical records, including pre-screening questions about these issues. So the employer has to be extremely careful about keeping all of this information confidential and separate from any personnel files. So in terms of reasonable accommodation, remember always that COVID-19, even though it may be a temporary disability, it's subject to the same requirements of any disability. So the employer must provide reasonable accommodation you know, if an employee requests reasonable accommodation because of COVID-19. So if you were to reopen, if an employee is susceptible to getting the virus but cannot take an injection for whatever reason, or is exposed to somebody in the family who has COVID-19, that person is eligible for reasonable accommodation under the Fair Employment and Housing Act. You know, a compromised immune system, that is considered a medical condition under the FEHA. The only exception, as just as any other type of reasonable accommodation provision, is that the employer can have a defense of undue hardship, which means significant financial impact in running the business, having to create another position for an employee, having to remove essential functions for the job, or displacing another employee. So these are existing defenses that an employer can still apply. Finally, in California, as you know, the interactive process is a standalone requirement under the FEHA. So pursuant to providing a reasonable accommodation, the employer and the employee must engage in a timely, good faith interactive process to find out the various effective accommodations for an individual who has a known disability. So it has to be a known disability or medical condition. Also, the same interactive process and reasonable accommodation would apply to a religious belief. So if somebody has a sincere religious belief that they cannot use injections, for example, and they need an accommodation, that is something that would trigger the interactive process pursuant to reasonable accommodation. Again, the employee must identify the specific accommodations that would be effective to permit that employee to continue to perform the essential functions of the job. These are some of the continuing potential leaves, if leave is an accommodation, that everyone should be referring to when you are advising your client about leaves as an accommodation. The California Family Rights Act, which has certain requirements about, you know, having worked 1,250 hours for an employer of a certain size, etc. But the California Family Rights Act is eligible. If the employer is not a FAMLA or CFRA employer and maybe a FAMLA employer, then the FAMLA leave is another possible basis for the leave. Pregnancy disability leave is another special leave under California statute. There's also a supplemental paid sick leave law specific to COVID-19 that can be a leave. There are other types of paid sick leaves available, and there's also accrued vacation time available. So in considering reasonable accommodation as to leaves, please take a look at all of these provisions. As we mentioned earlier, civil rights laws remain in effect during COVID. FEHA prohibits discrimination and harassment on various bases listed here, including disability and religion. The FEHA also prohibits retaliation for opposing any practice prohibited under the Act, or because the person has filed a complaint or testified or assisted in any proceeding under the FEHA, or for requesting an accommodation because of disability or religious practice. Michelle, do you want me to?
No, that's fine. Thank you so much. So we've gone over the hypothetical, and these are indeed some of the big issues that were raised and discussed. Can ABC require returning employees to inoculate for COVID-19? Can the employee refuse to be vaccinated because of their phobia, which, by the way, you know, then there's the question, is that a medical phobia, a needle phobia? You know, lots of issues there. Or religious belief, sincere religious belief. Does ABC have to engage in the interactive process and reasonably accommodate chef? And Phyllis has covered that. Did the employer discriminate, harass, or retaliate? Can they terminate and take on a brand new employee? What are the risks to them in this action? So I'd really like to ask, we'll start with Phyllis. What would be helpful to you in mediation of, let's say it's focused primarily on reasonable accommodation and interactive process?
Well, it would be very important for me to know whether or not this is a covered employer. Do they have 5 or more employees to be a FEHA employer? Is this a covered employee? And most people are. You don't even have to be an employee under the FEHA. You can be an applicant. You can be a volunteer. You can be a student intern. You can be a contractor. So almost everybody can come under the law there. So what's important to me is whether or not those initial elements are met. And if it's any kind of a discrimination because of disability case or a religious case, it's critical to know right away whether or not that was known, whether the employee informed the employer, because again, the employers are not clairvoyant. They have to be told, they have to know that there's a disability or a religious belief that needs to be accommodated. Then it's important for me to know and for the employer to show that there was an interactive process in which a reasonable accommodation was identified. And the employee both sides have to participate in good faith in that process. And I'd like to know what the reasonable accommodation is, whether that is reasonable. So if somebody were to just, employer were to just send an email or something to say, oh, well, let us know if you want to participate in a meeting about reasonable accommodation, that's probably not enough to show that there is an interactive process or reasonable accommodation. And it would be important for me to know whether or not there's, what the employee has asked for and whether that accommodation is reasonable, because it has to be a reasonable and not an unreasonable accommodation. Is it going to be an undue hardship for the employer? Is it going to be permit the employer to continue to operate the business? Is it going to displace another employee? For religious practices, for example, would it be unreasonable? I think would be to carve out a special part of the office or something like that for worship. Yeah, that would be unreasonable. But if it's a temporary space that can be used for various reasons, that would be fine. So much of this is fact specific, and it would be critical for the both sides to provide the factual information and the documentation to show that this occurred. In terms of the hiring and replacement of anyone who has been laid off, again, I would take a look at the new statute SB 93, because that has special requirements about who is supposed to be invited to come back, within how many days, when the refusal has to come in, within how many days. And that can be a very expensive proposition. What ABC here has done can trigger civil penalties of $100 per employee under SB 93, $500 liquidated damages for each day of the violation. It can trigger FEHA liability, back pay, front pay, emotional distress damages, punitive damages, and so forth. So the facts here can trigger a high risk for the employer.
So let me ask you, Mark, about other risks. I started thinking about, are these new laws going to be challenged in court, and how does that risk apply when we're mediating our cases? But tell me what you think are other risks.
I think Phyllis did an excellent job of highlighting the main picture. It all, to me, always goes down to the facts of each situation. the thoroughness of the employer's response to the circumstance, and obviously how that's going to play out if the case isn't resolved in front of a jury. Certainly some of these regulations and new laws may get challenged. That will probably be the case. But for purposes of mediation, it's really identifying, again, the facts and were people acting in a reasonable manner, and working backwards from that. I wanted to just mention, because it's 12:55, and I also want to make sure we get a chance to share some more information. We haven't yet gotten to some of the other topics. If you allow me, I might suggest we try to speed through some of the next things to get to best practices so that our audience can hear from both you, Judge Rosenblatt, and Phyllis, and maybe my 2 cents too.
Well, sure, I agree, but see, this next part is yours, so.
Well, then I'm gonna take the liberty here, folks. So as you heard at the beginning, you will get these slides. And you'll get Hypo 2, which I'm gonna jump past to talk about what's behind it, and even the map for thinking about Hypo 2 is in a later slide. So bear with me. Let's go to the next slide. So quickly, there have been some developments that have postdated the onset of COVID, and some of them are essentially how we are adapting to some pretty significant changes in the law, starting with the Dynamex opinion case, 2018 case, but where we are today is still figuring out how does it work, where does it work, and what are the implications. So as we all heard, Dynamex adopted the ABC test, much more pro-employee than pro-employer. Both the California court and federal court has recognized that is retroactively applied. And now, and obviously to the extent that the ABC test does not apply because there are exceptions, and the common law rules, or that is adopted in the Borello case, still apply. Not as dramatically different as I think sometimes people argue, meaning Borello versus the Dynamex test. So let me jump ahead, because I'm going to link these things together. So a lot of change in the law about triggered by Dynamex, which of course, can we get to the next slide? And then we of course saw the adoption or the codification of Dynamex in AB5, along with a series of exemptions that are built right into AB5. What I am seeing in a lot of mediations now is the issue of whether these exemptions apply to the particular position. Does this person constitute a lawyer or something else? Are they an architect or something else, and the like? That is going to continue to play out for some period of time. Can I go to the next slide? Also, as we're seeing right in front of our eyes, as we know, Proposition 22 just passed in contravention of what the legislature was trying to do, at least as to so-called gig workers, has led to a new round of litigation pending right before our eyes as to whether someone is, whether Proposition 22 applies, whether it's retroactive, whether it has any other, or whether it preempts other existing law. There was a decision, I think just in the last day or two, by Judge Phyllis Hamilton in the Northern District, Hassel versus Uber. I don't have the citation for you, but you can Google it. But it's a very interesting decision because it shows a judicial hesitancy about making some sweeping judgments about Prop 22 somehow trumping all other laws. I don't mean to use the word Trump, but it fits here. Trumping all other laws that are already in existence. I recommend that one. Similarly, as one example, I think we put it in the material, there's a decision. Let me see the next slide. I don't know where we've stuck it in. Really interesting decision just issued in the last couple of weeks by Judge Cheng in San Francisco Superior Court, which raises questions, I'll wait and mention it in PAGA in a few minutes, about the impact of Proposition 22 and rejecting the notion that it's somehow retroactive. So if I could go to the, so the slide we're looking at now, tracking break time, meal time, and the like. What we're seeing, I think, partly implicated by COVID, and I'm seeing in my current mediations, are a lot of interesting issues now that we've had the situation where people were told to continue working, but do it from home. Now we're looking into a hybrid world. I think we have a lot of new issues in play, but to the extent people are working from home, there is no abdication of existing employment laws. So you still have to track people's work against what the same expectations are. And that also includes meal breaks and overtime. It is getting tricky when people are not working at a place where they clock in and out in the traditional way, or you record time in the traditional way. And employers are struggling a little bit, as anybody should, with trying to make sense of how you would make those adaptations. That is starting to percolate through in terms of new filed cases and new mediations. What I'm excited about as part of that is the fact that more employers, as well as more employees, are seeking the help of a mediator earlier on, because it is a moving target. And I've always thought that was a great step in the right direction, to see if you can tackle the problems earlier. From my prior life, both mediating as a general counsel, I'm a true believer that the earlier you start this process of ADR, the sooner you can clear up ambiguities and find solutions. And if you're talking about in the employment area, where the ball is moving, where the targets are changing, there's also much more opportunity by tackling the problem earlier to come up with solutions that may allow us to adapt, to accommodate, that are much harder to do, if not impossible to do, if you let the dispute go much further. I also just want to quickly mention a case which I call sort of a philosophical second cousin to the Dynamics case, and this is the Gutierrez versus Brand Energy case that I'm just working with. And it stands for the proposition that even if in a collective bargaining agreement, of course, bargain between the employer and the union, that you cannot bargain away certain rights, even if everybody else thinks it makes sense. In this case, they had to do with what are called pre-shift travel time rights. And in that particular agreement, consistent with industry practice, the employer paid for post-shift time, but didn't pay for pre-shift time. Now, everyone thought in the collective bargaining agreement that was fine. The courts did not. So I think similar to Dynamics and Donahue, which we'll get to in a minute, we mentioned before, which has to do with the inability to do rounding of time for meal periods. I think these two cases, Donahue and Brand, stand for the proposition that no, you can't negotiate away or negotiate away from legal liabilities that otherwise exist under the labor code. So let's see, because I do want to get to, I want us to be able to talk about how this all fits together in best practices. So there's a couple of slides here with some highlights about PAGA. We could spend 2 or 3 hours just on PAGA. I think the main themes here are, please read these cases, because they involve a number of times where people have attempted to limit PAGA's reach, or in the case of like Kim versus Raines, argue that whether or not you can still pursue PAGA penalties, even if you settle individual claims. Kim versus Raines says you still can, meaning PAGA liability is still out there. Some of the more interesting cases that I deal with in my mediations obviously has to do with trying to settle these cases, and not only what's a reasonable value, but have the litigants done enough work to justify a settlement. Again, this is the reference I mentioned before. Its official name is Neutron Holdings Wage and Hour cases. It's the Lime Scooter case. And in this particular reference, Judge Andrew Cheng, it's misspelled here, it's Cheng, C-H-E-N-G, rejection of a settlement is a very thorough dissection about how important it is, just as with class actions, for the court to evaluate PAGA settlements for fairness. And it's a great roadmap for plaintiff's counsel and defense counsel to say, let's make sure we've done the work we need to do. And sweetheart deals, so-called reverse auctions, are not going to pass the smell test. And this is just one of 50 cases I've seen along these lines where courts are saying, not enough, it's not fair, it defies kind of logic and reason. So take these cases as your litigator, get on either side and go, what was not enough? And what are the court expecting for us? And do that, all that pre-work before you show up at the mediation. So I sped through that because I was hoping that we could use the remainder of our time to sort of talk about best practices, both in mediation and arbitration. We'll leave the hypo too. We'll skip past that.
Yeah, we can skip it. And so in mediation best practices, why don't we take the slide down and just go to speakers?
Great. So I was taking up too much time. I think, Phyllis, would you like to jump in first?
About best practices.
Sure.
We're focused on. Well, I think preparation is key to having any kind of hearing, whether it's mediation or arbitration or whether you're going to court. I think a lot of people, when they come into mediation, they believe that, well, they can just recycle a complaint or a motion, but really spend the time on preparing a brief that is persuasive. That is not too long. I always ask the parties to provide me with a brief, describing the law and the facts and their major arguments within up to 10 pages, but then any number of attachments that would be relevant, of course, by email. I also always prepare in a pre-mediation conference call with the parties. I ask the plaintiff's counsel to please break out plaintiff's settlement demand in a way so that I can understand how they reached the number and help them settle the case. I also ask plaintiff's counsel if it's possible to, in advance, provide at least a bottom line settlement demand to the defendant, because as you know, businesses, employers will need to get authority, and really it would really help the case along if that authority can be sought or at least determined in advance. Also, to put everybody in the right frame of mind to settle the case, I also always ask the defense to provide a blank settlement agreement template and provide that in advance to the plaintiff side so that there are no surprises about what kind of language you can get in. They can ferret out and change, amend any language that may not be palatable, may not meet their requirements. And I always say, well, at the end of the mediation, if we mediate the case, you just need to plug in the information. We can have a counsel meeting only separate from clients and get the case settled. So preparation in advance to put everybody in a settlement mode, I think it's really, really critical.
So just a couple of things, and then I'll pass it to Mark. Consider sharing the brief. It's okay if it's a redacted copy that goes to the other side, but just like giving an opening number in advance is helpful. Also, sharing the brief is helpful. Knowledge is power, right? It helps the parties. There may be reasons that you don't want to, so we can talk about it in a pre-mediation call and see what to do about that. If it's pre-litigation, how about sharing information, even financials? If financials are going to be an issue under a mediation confidentiality type of an agreement. Try not to give an MSJ instead of a brief. The brief is briefer and it's kind of more succinct. Mark, what do you think?
Well, I agree with both of you, and I'll just expand a little bit. And if anybody's interested, please go to my individual website. It's marklehocky.com. Connect by LinkedIn. I write extensively on this. to me, the biggest miss sometimes is the lack of preparation by lawyers. And I don't mean just preparing what they're going to give me, it's preparing their clients. And again, going back to Phyllis's earlier work, where it's about persuasion. But unlike a matter where you're in court in front of the arbitrator, you need to not just persuade me as the neutral, you need to persuade the other side to change their position. So it's a fundamentally different exercise. And if all you've done is taken your last, nasty gram brief about the other side being reprobates and gold diggers and things, you're not going to have the right reaction. So if it becomes the nasty gram, what you're going to do is get the response of the childhood phrase, I know you are, but what am I? People do not listen when they're attacked. So take out all the invective, write a different brief. If you feel like you have to write a nasty gram brief, first of all, share your brief. I'll get back to that in a second. If you feel like a nasty gram is important, your client feels like you should write the nasty gram, you write a separate supplemental brief and give that to the mediator. By the way, none of us are going to get excited about it. If we don't like the nasty gram approach either, because it doesn't really work. But if you need to do it in a separate communication, but share your brief. And again, if you don't share your brief, what happens? If you don't share your brief, your client, your insurer, if you're on that side, or the corporate executive team, they all get more excited about your position because they really haven't gotten an honest depiction of the other side's position. As somebody who worked in large corporations as well as small firms, sometimes you have multiple levels of decision makers who weigh in on a matter. And among other things, that takes time. So you need to not only share your brief, but get your brief in as soon as possible. One of my cases a while ago, I was always struck by because I got the brief in 6 weeks before the mediation. And I literally checked my calendar and said, I must have screwed up yet again on my calendar. And I called the lawyer and said, I don't think we're going to see each other for 6 weeks. And he said, oh, we're not. But I wanted the brief to get to you, and I wanted the brief to get to the employer and the employer's carrier, because in this particular case, and he was right, this is not your run-of-the-mill case. It was a horrific case. And he knew that it was going to take time to process through that on the other side. And so think not just about timing. When people like me say, get your brief in a week early, it's not just for me. It's to allow the other side to process up the food chain. I'll also second what Judge Rosenblatt and Phyllis said in terms of more information is better. I err on the side of transparency as a neutral. People get worried about that. There's something super secret we don't want the other side to know. It's real easy to say, here's the super secret stuff. We're going to park that. Be prepared for me or Phyllis or Judge Rosenblatt to say, is this really super secret? Because probably it's not, or you're going to have to disclose it anyway. But even if there's something super secret, park that in that little piece, share everything else. One of my rules when I was general counsel, if I couldn't go to mediations myself, and I couldn't go to most of them, I got to do a lot, was my team was not allowed to go to the mediation without having multiple direct conversations among the lawyers on each side. Now, why do you do that? I've had many people that show up before me say, well, that's what you're here for. And I go, yeah, I am. But if you engage ahead of time with the other side, you will be better informed and they will be better informed, and everybody will set better expectations when we come together. So pick up the phone. I know it sounds old-fashioned, I apologize for that, but don't text, don't email, pick up the phone. Now we can do it again. Go meet in person, have that kind of legitimate conversation. We're not seeing what you're seeing. Let me tell you why I think it's this. Tell me why you see it differently. I know it sounds real old-fashioned, I'll accept that, but you're always going to be better informed by doing that process. And then finally, in the class action PAGA area, share the information that's essential to have a meaningful negotiation. I've had too many situations where people show up and they've not shared the basic data about number of work shifts and all of that. And no one can meaningfully put together a settlement that will pass court muster unless you do some of that work. You know, work your calendar to make sure you've exchanged the basics to have a meaningful conversation. And lastly, I know there's a contrary point of view that we don't share anything because that's strategic and we want to keep it in our back pocket. Once in a while, I concede that there are situations where it's valuable to say, I can't go to mediate with you until I get one deposition done. When I used to do it, I only wanted to do 4 hours with this witness. You can agree to come back later. You can do 4 hours with my witness. I don't suggest that as a regular process. Once in a while, for a bunch of strategic reasons I won't worry with. I did that because I didn't want them to know why I was asking the questions till I asked the questions. That happens 1 in 50 times that really takes place. The rest of the time you can go forth, you can guess what they're going to say. They've already put in their complaint and the answers. But go in with as much information, fight the urge to be super secret and transparent. I mean, it's super secret about the approach, and you'll get more done.
So just a little bit to add on the class action PAGA piece. If you have your proposed MOU or proposed settlement with you that you can change and apply to the current case, that's going to be really, really helpful. If you have just enough discovery done that that everybody's informed about class size, proposed members, the same job descriptions, enough general discovery so that when you go to court, and this is really something that Mark hit on and with one of the cases, enough general discovery to satisfy a court that you've explored the issues enough, because the court is there to protect the class or protect the PAGA plaintiffs. And if you don't do that, then all that work that you've done is not going to work. So Phyllis, did you want to say something?
I just want to add one more thing that we didn't talk about, and that is have your client present the whole time. Have anyone that is key to the decision-making there the whole time. Unless the parties have skin in the game, it's very easy to say no or to not be engaged. So have them there and tell them this is really serious and will help settle the case.
Okay, I second that. Okay, so could we go to the next slide, please? Okay, yeah, next slide, please. Thank you. So I'm going to follow Mark's lead because it's 1:15 and tell you that that I'm not going to read this hypo to you, but it is a great example that kind of goes with the latest arbitration cases that were worthy of pointing out for today. So could we go to the next slide, please? Okay, so just really generally, PAGA cases aren't arbitrable, but in these cases, creatively, the side that wanted the case moved into arbitration said, well, if we can't arbitrate our case or our PAGA cause of action, at least can we have this finite issue, this gateway issue of whether an aggrieved employee is entitled to raise claims under PAGA in arbitration, or the threshold question of, is plaintiff an employee or an independent contractor? The courts still say no PAGA. That's all for the court to decide. And I'm just going to suggest that you look at all of these cases that talk about class action waivers. when a class action waiver is enforceable under California law, we've seen that the individual cases are still going to arbitration. Here in Bentecourt, it's the opposite situation where there was an unenforceable class action waiver, but still the court was told they should have severed the individual claims so they could be sent to arbitration. And there's actually quite a bit more to that case. When you've got a collective bargaining agreement, you have to look when you have statutory claims as to whether or not there is a clear and unmistakable waiver of the right to judicial forum. That's the term. And then when you're talking about federal court cases, Title VII related statutory claims, again, you have to look at the standard, whether there was a knowing waiver of judicial remedies. Can we go to the next slide, please? Appellate review provisions in employment arbitration agreements are being scrutinized. In this case, even if that is stricken, then that doesn't render necessarily the entire agreement, arbitration agreement, unconscionable. And then when it comes to judicial merits review of an arbitration decision, I'm just going to refer your attention to Mark LeHocky's article, which is one of the items that you are going to receive. He does a beautiful explanation of this case, but the bottom line is even if the legal decision technically cannot be challenged on appeal, if it can be viewed as exceeding powers, then it certainly can be subject to a motion to set aside an arbitration agreement. And there's much more to Brown that you should look at. So let's go to the next slide. Thank you, Phyllis. And so here again are the various questions that come up from this that I'll refer you back to, no PAGA and so forth. So we're just going to skip it and go to best practices. That's where we really belong, right? So I'll just start with you, and then I'll turn it over to Mark. So just a couple of things about this. You can read it yourself, but just because you have an arbitration agreement and you are in arbitration, whether it's by choice or it's not by choice, doesn't mean you shouldn't look at the rules that have been contracted for in the arbitration agreement and approach the other side and say, hey, can we formulate a stipulation to use certain other rules for discovery? Also, very important, once an arbitration award is final, it's final. It's final. Okay, you can't ask for things afterwards, except for one exception, which I'll talk about in a minute. But that means that if you're going to be bringing a motion for attorney fees and costs, make sure that your arbitrator plans to issue an interim award and that you can then bring the motion for the request for attorney fees and costs, or if there's some other methodology that your arbitrator wants to use, because once you have a final award, the arbitrator is not going to be able to consider an award of attorney fees and costs. But in the Heimlich versus Shivji case, which was specific to 998, the court does go through a very interesting analysis, comparing it to a court judgment and then a request for costs on why a a shifting of costs should be considered due to a rejected or not responded to 998, even after the deadline. But the best practice is to try and have all that done before a final award. In treating an arbitration like a trial, I just want to mention quickly this Grabowski case. It was a pro per case, pro per plaintiff who left the room, had his phone on record, which is a whole other question. And while he was out of the room, the defense counsel and the arbitrator were shooting the breeze. Okay, so it's like all about why would somebody not have a lawyer here? Why do you think this particular litigant didn't have a lawyer? And guess what? That arbitration was overturned. I think it's because we're more comfortable in the arbitration setting, right? It doesn't feel like a courtroom, and because it's less formal, that it's easier to just have a conversation. But guess what? It's a problem. So try to treat your hearing like it's a trial, no ex partes. And the one thing I want to say about your arbitration brief being key relates back to the fact that if the arbitrator gets the law wrong, you are stuck with it, with the exception of exceeding the powers situation. So it's important for you to put the law that you want the arbitrator to apply in your brief. And also, if there are specific issues that you want called out in the decision, please bring them up. I'm going to turn this over to Mark. You want to add?
So I agree completely with all your comments, Judge Rosenblatt. A couple of basic themes in my mind is think about efficiency. One of the biggest gripes people have about our arbitration process is it is expensive. As I said, as an arbitrator, I look at the time that I'm charging people, and it's like, it's a lot. It doesn't need to be. And a lot of that just has to do with really putting the effort into the meet and confer process, finding an arbitrator. We're not all the same. Some of us have particular rules. I have a process where I don't let anybody file any motions or things with me until we have a pre-call to determine if we need to file the motion. And the vast majority of the time, there's not a need to file a motion. Based upon the conversation, we work out the problem much more expeditiously. Contrary to the notion that arbitrators are looking to maximize their income, what they're doing, what we're trying to do is help solve the problem faster, sooner, quicker. And indeed, I'm happy to say most of my arbitration matters don't go fully to a hearing because they don't need to. So if we're looking at this in terms of case management, what's the path towards getting it resolved sooner rather than later, good things can happen. But it takes really active involvement with the lawyers. And just as I said before, pre-mediation, the importance of the lawyers actively talking. The fact that you're in arbitration, you should not stop talking. You should continue the conversation to solve as many things as you can. And guess what? Most of the time, you're going to probably go off and settle the case anyway. That is a good thing. That is a good thing. It's not our goal to have as many arbitration days as we can. It's our job to help you solve your problem.
Exactly, and most arbitrations do settle, rightly so. And one of the very important things, it's in the slide as well, is if you meet and confer not only about what exhibits you have and what stipulations to authentication and foundation you'll have, but about stipulating two facts that you both agree on. In arbitration, it's less about the theatrics of it for a jury, right? So if you present those stipulated facts, you can save hours and days and get to really the meat of the matter. Phyllis, I don't know if you have anything to add, but I would like you to share the screen, take the screen off if you don't mind. Yeah. So just to say, we're going to talk for a minute about best practices in remote and hybrid arbitration hearings. So look into the camera, lean in for a close-up. Get a tutorial specific to your video platform, so you know your screen share and everything else you need to, and practice it and prepare your clients and witnesses too. That's so important. Take your breaks. It's hard sitting in front of a screen, and also you need the breaks so that you can check off everything you need and confer with whoever you need to confer with, your partners and associates, your clients, just like you would if you were sitting next to one another. And just a brief word about maintaining the same decorum that you would as in a courtroom. You're not in the courtroom. It's not going to be the same, but the big gulp next to you is just, kind of odd. And what about when you stand up and, for a break, and the arbitrator sees you in your shorts? Do you care? That kind of a thing. Anything you want to add, Mark?
No, I think you've hit it, and I think we're at time. I know, Hayward, you're probably going to come on to say what we want to make sure to convey is we powered through a lot. There's a lot of material there in the slides. Feel free to reach out to any of us, connect with us via LinkedIn and the like, because there's a lot more to cover than we could in this time frame.
It's true. I'm not on LinkedIn because of all the arbitrations that I do, but email me. I see there are so many questions in the chats and so forth. I'm so sorry that we just haven't had time to get to them, but we are available by email. You are going to see our email in when you get our materials. At that, I want to thank Phyllis and Mark for your amazing presentations. And Hayward, I turn it back to you.
Thank you, presenters. That was a wonderful program.